This is Duke University.
Good afternoon and welcome. My name is Guy Charles. I'm a law professor here at Duke. Dean Levy is out of town and could not be here this afternoon and has asked me to introduce our distinguished speaker, Professor Randall Kennedy from the Harvard Law School, the Michael R. Klein Professor of Law. He is continuing the series of lectures that he started yesterday, extremely stimulating. We're looking very much to his remarks today and having him back in about a month or so to continue those lectures. Thank you so much for coming, and now I'd like to present Professor Randall Kennedy.
Thank you very much, Professor Charles. And before going further, I'd like to thank you for your well wishes and encouragement and good counsel over the years. Thank you. Yesterday, I focused on an obscure episode in the civil rights movement, the episode involving Mary Hamilton when she refused to answer a question unless a state prosecutor called her by her full name. And my remarks were really focused on the case that arose from that refusal on her part, Hamilton versus Alabama. Today, I'm going to focus on a very well-known episode in the civil rights revolution, indeed an iconic development, the Montgomery bus boycott. The Montgomery bus boycott has been the subject of television shows and movies. Some of the people who were leading figures in the Montgomery bus boycott are known the world over. Martin Luther King Jr., Rosa Parks. The Rosa Parks stamp was just inaugurated. These are people who, I'm sure that there are questions on SAT tests that asks students to identify Rosa Parks, and in fact, I would suppose that for many students that would be a gimme of a question because she's now so well known. The subject today is going to be about the delegitimation of de jure segregation, and the case I'm going to really focus on is a case that arose from the Montgomery bus boycott, a case called Browder versus Gayle. Now, I'm going to give an overview of the story. I'm sure that this story generally is pretty well known, so I'm going to go through it pretty quickly, and then I'm going to focus on a couple of points that might not be so well known about the case and that might generate some useful discussion. But here's an overview of the story. So, on December 1st, 1955, the evening of December 1st, 1955, Rosa Parks is on a bus, and she's seated in the black portion of the bus. And this is a subject that I think often gets overlooked in the story. I mean, Rosa Parks, when she gets on the bus, is actually accommodating herself to the rules of segregation. There was a state law in Alabama that said that buses, and in fact all modes of intrastate transport are subject to segregation. And there was also a municipal ordinance that said straightforwardly on the buses, people of different races are to be put in different places on the bus. And Rosa Parks was being attentive to that. She goes to the back of the bus. She's in the black section of the bus. Now what happens is the bus fills up, and there comes a point at which the white section of the bus gets over full. And so the bus driver turns around, and here the case, by the way, gets a little bit complicated. There are two versions of the story. One version of the story is that there were a couple of white people, 3 white people, who needed seats. And one version is the bus driver turns around to where the bank of the row on which Rosa Parks is sitting and asked the black people to get up and move for the three white people. Another version of the story is that there was just one white man who needed a seat, and that the bus driver turns around and tells the three black people who were seated, we want you to get up and move, because there was an unspoken rule in the segregation etiquette that blacks and whites were not supposed to sit on the same bank of seats. And indeed, in some cities, there were laws that stipulated that. Blacks and whites were not supposed to sit on the same bench, or they were not supposed to sit on the same row of seats. Whatever story is true, the fact of the matter is the bus driver turns around, and this is uncontroversial, the bus driver turns around, asks black people to move. The black people seated next to Rosa Parks, they move, but she refuses. She refuses, and she just stays seated. The bus driver calls the police. She is arrested. In the aftermath of her arrest, an organization is created, the Montgomery Improvement Association. A young pastor who I'll get to in a moment, a relative newcomer to the community, a fellow who's only 26 years old, Martin Luther King Jr., is asked to be the head of the Montgomery Improvement Association. And the community decides to protest this arrest of Rosa Parks, who was a well-known figure in the black community in Montgomery. They decide to start what they envision as a one-day boycott of the buses. They think one-day boycott. Well, the envisioned one-day boycott becomes a consumer strike that goes on for 382 days, from December 5th, 1955 to December 21st, 1956. Now, after the boycott had been going for a while, a lawsuit was initiated, the lawsuit known as Browder versus Gayle. Gayle was the mayor of Montgomery. Aurelia Browder was the lead plaintiff. And one thing about the lawsuit was brought on February 1st, 1956, 2 days after Martin Luther King Jr.'s house was blown up for the first time. Now, his house was blown up a bunch of times during his lifetime, but this was the first time. And so the lawsuit is brought, a couple of months goes by, a three-judge court holds that the state and municipal laws are invalid under Brown versus Board of Education. The city authorities played tough throughout. Even after the United States, a three-judge United States District Court had invalidated the municipal law and the state law, the city authorities, said, well, we're appealing. They appealed to the Supreme Court of the United States. The Supreme Court of the United States, in an unsigned per curiam decision, summarily affirms the court below. But the city authorities still stand pat. They say, okay, well, we are going to petition for a rehearing before the Supreme Court of the United States. And that takes about another month. And only when the Supreme Court of the United States had refused the petition for a rehearing, it was only at that point that the city authorities indicated that they were going to cease their enforcement of the segregation laws on the buses of Montgomery, Alabama. Now, a couple of points of interest. Point one, what's the relationship of the boycott to Brown versus Board of Education? Brown versus Board of Education was decided May 17th, 1954. May 17th, 1954. Remember what I said, Rosa Parks was arrested on December 1, 1955. And that lawsuit, Browder versus Gayle, wasn't brought until months later. It wasn't brought until February. It wasn't initiated until February 1, 1956. You might ask the question, well, gosh, in the aftermath of Brown versus Board of Education, why isn't it that the lawyers representing Martin Luther King Jr. and Rosa Parks and all, the folks in Montgomery, why didn't they just immediately go to court and get these segregation laws invalidated? Well, one thing we got to remember is Brown versus Board of Education meant something different in 1955 than we, looking back now, perceive it to mean. I actually asked Fred Gray, Martin Luther King Jr.'s a lawyer, why? Why? I asked him. I said, I had an interview with him a number of years ago. It's been a while ago now. I asked him, I said, well, why didn't you all just sue? I mean, why'd you have this big boycott? Why didn't you just sue to attack the segregation statute in light of Brown versus Board of Education? And he said, we weren't thinking that way. We weren't thinking that way. Do we know about Brown versus Board of Education? Yeah, we knew about Brown versus Board of Education. But we didn't think that Brown versus Board of Education just immediately erased the segregation statutes that covered the buses. Brown versus Board of Education says that segregation in public education has no place. Well, that's the Supreme Court saying that segregation in place in public education, in primary schools and secondary schools, has no place. That leaves open the possibility of segregation having a place on the buses, or in other activities. So it wasn't altogether clear what Brown versus Board of Education meant, and a lot of work had to be done to clarify that issue. And indeed, one of the points of the fight in Montgomery was indeed to clarify the issue. Second point of interest. We look back now, and oftentimes people say, well, Rosa Parks and company were attacking segregation on the buses of Montgomery. It's not exactly true. They ultimately came to attack segregation on the buses of Montgomery, but not initially. Not initially. Rosa Parks was in the black section of the bus. As far as she was concerned, in fact, one of the things that angered her was she was playing by the rules. She was in the segregated section. But that wasn't enough for the bus driver. The bus driver wanted to oust Rosa Parks from the black section of the bus. And it was at that point, there she drew the line. The protesters, even after Rosa Parks was arrested, even after she was arrested, even after the Montgomery Improvement Association had been created, the black dissidents in Montgomery were still not attacking segregation. When they entered into negotiations with the city authorities, they complained, but their complaints were unfair treatment within the bounds of segregation. What were their complaints? Their complaints were things like this. They complained about discourteous drivers. They complained about drivers refusing to make change for black people seeking to get on the bus. They complained about drivers who would strand black riders. Back then in Montgomery, what would happen is, if you were a black person seeking to get on a bus, the way you got on the bus was this. You would go in to the front and pay your money, and then you would get off the bus, go to the back of the bus to get on. Well, what often happened is black people would pay their money, and then a driver would just pull off. Ha, ha, ha. And, Rosa Parks and Martin Luther King Jr., they entered into negotiations with the city authorities, with the authorities that ran that owned the bus company, and they said, we don't like this. We want something done about this. They didn't like the idea of black people being evicted from the black section of the bus. So what Rosa Parks and Martin Luther King Jr. and Joanne Robinson, the Women's Political Council, what they said was, we can live with segregation, but we want it to be administered fairly. So what let's do is, let's not have any more evicting black people from the back of the bus. Let's just have a system where white people get on the bus, and you have the white half of the bus and you have the black half of the bus. If it turns out that the white half of the bus gets all filled up, well, that's just tough. City authorities said, no, that's not good enough. And in fact, there was one lawyer in particular who had a crucial role in the Montgomery bus boycott. He was a man by the name of Jack Crenshaw. He was the lawyer for the bus company. And he was the person who thwarted all compromise. Because when the black dissident said, well, let's just divide the bus in half, the white people can take the first half of the bus, the black people take the second half of the bus. Crenshaw, a Harvard Law School alum, I have to say, his position was, oh no, that would violate municipal law and state law. Now, that's just simply untrue. The municipal law and state law simply said you got to have segregation, but it didn't say anything more. It didn't give any particular rules. It didn't set forth in a minute way how to administer that. It just said that black people and white people should be kept in separate parts of the bus. We know now that Crenshaw, for other reasons, wanted to thwart compromise. He said we later found out that he wrote memos in which he said, if we compromise on this will be giving the black people a victory. And we don't want them to have a victory. Because if they get a victory, they'll get boastful. You give them an inch, they'll want a mile. So let's rub their noses in it and be tough and just say no. And that's what he did. God bless him. Because by thwarting compromise, he forced Martin Luther King Jr. and E.D. Nixon and Fred Gray and Rosa Parks and the others to make a decision. Well, are we going to back? Or what are we going to do? And they thought about it. And the black dissidents in Montgomery were also getting pressure from another area. They were getting pressure from the NAACP in New York. The NAACP, the National NAACP in New York, was actually angry with King and the others in Montgomery because they were willing to accommodate segregation. The position of the National NAACP was attack segregation. And in fact, the NAACP refused to give the people in Montgomery any financial help so long as they were unwilling to attack segregation per se. It was only when they were willing to attack segregation per se that the National NAACP said, okay, now we'll give you financial help. Now we'll send our lawyers down there to help you out. So the people in Montgomery, the black dissidents in Montgomery, really had to sort of figure out, well, what are we going to do? And it was because of the recalcitrance of the locals in Montgomery that they said, we're going to step it up. Before we've been willing to accommodate segregation, we're not willing to accommodate segregation. We're going to attack segregation. Third point, let's talk for a minute about Martin Luther King Jr. Again, Martin Luther King Jr. was 26 years old. This was his first foray into civil rights politics. This was his first civil rights demonstration. He was a pastor. This was his first pastorship. He was a pastor at the Dexter Avenue Baptist Church. A little digression here. A number of years ago, I went to Montgomery to read the transcripts of various trials that emerged from the boycott. And I remember the very first day, I went down to the basement of I was in the basement of the Supreme Court of Alabama. And I spent the day down there reading transcripts. And at the end of the day, I finish. And I go to a guard. And I say to the guard, I'm from out of town. I'd like to go to the Dexter Avenue Baptist Church. Here's the address. Could you tell me, how far away that is? And he looked at me sort of strangely. And he said, it's right across the street. I said, right across the street? He said, oh yeah, just come here. He pointed to you. You could throw a rock from the Alabama Supreme Court to the church that Martin Luther King was the pastor of during these events. The Dexter Avenue Baptist Church is right across the street from the Alabama Supreme Court, and it is right in back of the Alabama State House. I'm really surprised, actually, that movie makers haven't made more of this. So here you're at the Dexter Avenue Baptist Church. You have these plaques talking about the history of the Montgomery bus boycott, plaques about Rosa Parks, plaques about Martin Luther King Jr. You'll be reading one of these plaques, and then you'll look over, and there'll be a statue to various Confederates, cheek by jowl. This was Martin Luther King Jr.'s first civil rights foray. Martin Luther King Jr. is, of course, now very well known for various contributions. Two of his greatest, Letter from a Birmingham Jail, a great brief. Every law student should read Letter from a Birmingham Jail. It's just as a performance and advocacy. It's a wonderful lawyerly brief. And then, of course, his I Have a Dream speech. The world over, anthologies of great speeches include the I Have a Dream speech. In my view, the speech that he gave the night that the boycott began is as moving as those two performances. It was a very busy day. He had about 20 minutes to prepare. He gets up in the pulpit and he talks to the church. The church is just filled to the gills. You couldn't get in the church. They put loudspeakers outside the church. There were estimated about 1,000 people outside. And you can actually hear the speech. There's a wonderful documentary from Montgomery to Memphis. It's a documentary about the life of Martin Luther King Jr., and it begins with the speech. They don't show Martin Luther King Jr., it's just a black screen, and you see the words of the speech, and you can hear it. And it's a fabulously good speech. Let me read a little bit of it to you. This is the way he begins it. My friends, he begins, we are here this evening for serious business. We are here in a general sense because first and foremost we are American citizens and we are determined to acquire our citizenship to the fullness of its meaning. We are here because of our deep-seated belief that democracy transformed from thin paper to thick action is the greatest form of government on earth. But we are here in a specific sense because of the bus situation in Montgomery. We are here because we are determined to get the situation corrected. Now, at this point, you hear this enthusiastic response, just this swell of enthusiasm. And then he continues. There comes a time when people get tired of being trampled over by the iron feet of oppression. We are here to save ourselves from the patience which makes us patient with less than freedom and justice. And then he goes on. My friends, don't let anybody make us feel that we ought to be compared in our actions with the Ku Klux Klan or the White Citizens Councils. There will be no crosses burned at any bus stops in Montgomery. There will be no white person pulled out of their homes and taken out to some distant road and murdered. There will be nobody among us who will stand up and defy the Constitution of this nation. And then he goes on, and it's just a wonderful speech. Again, virtually extemporaneous. Again, he had about 20 minutes to prepare. Point 4, the bringing of the lawsuit. The name of the lawsuit is Browder versus Gayle. You might ask, well, where's Parks? Here's a good lesson for law students. When Rosa Parks was prosecuted, initially, when the case came up for trial, her lawyer did seek to raise the constitutional issue as part of her defense. But that issue was lost to him because of a procedural mishap. Pay attention to procedure. That procedural, because of a procedural mishap, the constitutional question was lost. When that was lost, so that possible defense was lost to her, and in fact, she was prosecuted, in fact, convicted. A bit later, when the folks in Montgomery decided to bring suit, they brought suit on behalf of Aurelia Browder and others in federal court. There was a lawsuit brought before Browder versus Gayle. A lawsuit was going to be brought, and in fact, I think the papers were filed on behalf of a young person by the name of Claudette Colvin. She was going to be the named plaintiff in the federal lawsuit attacking the state segregation law and the municipal segregation law. But that lawsuit was abandoned when her parents objected. Her parents objected because after the lawsuit was brought, it turned out that her parents found out that she was pregnant but not married. And the folks in Montgomery took the position, well, this will be looked down upon. This will be something of an embarrassment. So they said, her parents said, we don't want her to go forward. And so the lawyers sought people like Aurelia Browder, very well-known person in the community. Nobody could say anything about Aurelia Browder. It was for that reason that the case is Browder versus Gayle. Again, a little tangent here. This issue of the nature of the name plaintiff. That's an issue that came up over and over and over again during the Civil Rights Revolution. It's an issue that was constantly on the minds of Thurgood Marshall. Thurgood Marshall was always very attentive to the character and the reputation of the people who were the named plaintiffs in his lawsuits. In fact, he always engaged in an investigation. He himself would investigate the people who would be the named plaintiffs. And if he did not think that the named plaintiff was a good person to be on the front pages of the newspapers, he wouldn't represent them. You might, Marshall and the people who came after him were definite believers in what some people now refer to as the politics of respectability. Marshall above anyone. He was very punctilious about this. In fact, there was a long period in Marshall's career where he would not represent people in criminal cases who he thought were guilty. But that's what happened. They picked 4 people who they thought were just above reproach. And those were the named plaintiffs in Browder versus Gayle. One other point about this litigation, the idea of litigation, Martin Luther King Jr., from an early period, again, remember this is his first civil rights action, was very conflicted about litigation. And in fact, he stayed conflicted throughout his life. One of the reasons that he did not initially want to engage in a lawsuit was because he viewed lawsuits as being too confrontational. He said, I prefer negotiation. Lawsuits have winners and losers. He said, that's too confrontational. Let's try to negotiate this. And in fact, the reason they brought the lawsuit was because of the bombing of Martin Luther King's house. After Martin Luther King was bombed, Fred Gray and company said, okay, we're going to fight fire with fire. Their sort of fire was bringing a lawsuit. So, for people in this room, people bring lawsuits all the time. We don't, like not anything of bringing a lawsuit. In 1955 in Montgomery, the meaning of bringing a lawsuit was very different. It was viewed as a very confrontational sort of crossing of the Rubicon. Later in King's life, he had a somewhat different view of litigation. There were times when he was against litigation because he didn't like litigation because he thought that litigation in a way was too conservative. It only involved the lawyers. It only involved fighting in the courtroom. And he liked bringing masses of people to the street. He liked mass organization. So he had the idea of litigation to Martin Luther King Jr. actually meant different things. And it's a sort of a tip-off for us that litigation can mean a wide variety of things. Nowadays, sometimes people view it as very conservative. Well, it all depends. It all depends on the circumstances. It can be a conservative mode of reform. Can be a conservative vehicle of reform, but it doesn't necessarily have to be. 5, the nature of the boycott. This is a subject I just love reading about the Montgomery bus boycott and revisiting it. I find it just absolutely thrilling to just think about. I mean, an absolutely remarkable moment. Here are these folks in Montgomery who have been subjected to humiliation. They have been subjected to subjugation. They have been excluded. They have been just in every, the thumb of white supremacy has been imposed on these people. And then in 1955, in the midst of all of this, the people of Montgomery, Alabama, just declare independence. For those 382 days, I mean, if you're talking about, if you are a student of democracy, in the history of the world, this is a great moment. They declare independence. They have their own government. They create a newsletter. They create their own alternative mode of transportation. They boycott the buses, but they have to, they're working people. The black people in Montgomery, they're working people. They got to get to work. What do? They create their own mode of transportation. Any black person who's got a car in Montgomery, we need your car. Those who, can't get a car, walk. And they do this for 382 days. One of the great things about the boycott is nobody at the outset thought that they could do it. No, they didn't think they could do it. They did not think that they would be able to hang together to do it. And King, in his first, again, going back to this speech, Martin Luther King Jr. speaks to this issue. Now, King, is known very much as an integrationist, as he was throughout most of his career. there's a part of his speech where he sounds like Marcus Garvey. It's a very interesting speech. He talks directly to the black people of Montgomery, and he says, this is an important moment. And he says, let's comport ourselves in such a way that when the history books are written, well, here it is. Here it is, that night. As we prepare ourselves for what lies ahead, let us go out with a grim and bold determination that we are going to stick together, so that right here in Montgomery, when the history books are written in the future, somebody will have to say, there lived a race of people, black people, fleecy locks and black complexion, who had the moral courage to stand up for their rights. That's what he wrote on the first of those 382 days. And they did. They stuck together. And they stuck together so well, the bus company wanted to give up. The bus company said, we're losing a lot of money. Can't we negotiate? And the city authorities by that time, because the stakes had been raised, said no. The bus company wanted to negotiate. The bus company essentially abandoned its lawyer, Crenshaw. But the city authorities said no. The boycott continued. And then the city authorities started a campaign of harassment. So I mentioned before that Martin Luther King Jr. was, a young person, 26 years old. So was his lawyer, Fred Gray. This was Fred Gray's initiation into law practice. That's right. Rosa Parks and Martin Luther King Jr. were his first clients. He had just graduated from law school. He went to Case Western Law School. Why did he go to Case Western? Why was he in law school in Ohio? Because he couldn't go to law school in Alabama. He had to go to Ohio to law school. He comes back to Alabama, and this is what he confronts. Well, when he represents Rosa Parks and Martin Luther King Jr., when he comes back, he had a deferment. He had some, I've forgotten why he had some deferment. I think it might have been some health problem. Well, what do the local authorities do? They change his draft status and make him subject to the draft. They charge him, they trump up something and charge him with some unethical conduct, barratry. This happened to lawyers throughout the Civil Rights Revolution. There's all sorts of harassment of Martin Luther King Jr. Police officers get behind Martin Luther King Jr. whenever he drives. In fact, he stopped driving because this happened. He'd be in a car. They'd pull him over for staying too long at a traffic light. You're at the stop sign too long. Okay, here's a citation. Next day, you weren't at that stop sign long enough. He was constantly being ticketed, as were others. When people would, car full of people, police would just pull them over, citations here and there. The most serious instance of harassment was when the state authorities indicted Martin Luther King Jr. and 89 others in Montgomery for the crime of conspiring to hinder a business without cause. And in fact, this led to a trial. One of my favorite stories about the Montgomery bus boycott. So, the idea of being indicted, the idea of being arrested, the idea of going to prison, heretofore, those things were horrible. especially for, sort of middle-class black folks. I mean, this was just the most horrible thing that could have ever happened. When Martin Luther King Jr. was indicted, people surrounded Martin Luther King Jr., and it became a mark of distinction to be indicted. The 89 who were indicted with them immediately became celebrities in Black Montgomery. I mean, that was the mark of having arrived. And people, on the very first day of trial, people, dressed up, really dressed up, and went to the trial and were happy to be there. He, it turns out, was the only one who was actually tried. He was tried, he was convicted, he was, a $500 fine. Very interesting trial in various ways. But there were all sorts of things that the authorities did to get tough. But all of them failed. All of them failed. The boycott, remained. The solidarity was achieved. And then the lawsuit, the federal lawsuit, ended with success. The three-judge panel that invalidated the state law and the federal law, the state law and the municipal law, there were three judges, Reeves, Johnson, and a segregationist named Lynn, Judge Lynn. The segregationist dissented. His basic position was, well, the Supreme Court of the United States has not invalidated Plessy versus Ferguson. Brown versus Board of Education was about public education. It didn't say anything about intrastate transportation, so lower federal court judges should not take it upon themselves to go further than the Supreme Court of the United States. Frank Johnson and Reeves were willing to take that step and strike down the law. And then again, the Supreme Court of the United States backed them up, again in a summary way. They did not write a full opinion. They simply said, we summarily affirm the lower court, CEG, Brown versus Board of Education. Last point, limits and achievements of the boycott. 1.1, as great as the boycott was, as successful as it was, litigation was necessary. One of the things I learned about the Montgomery bus boycott was that the people engaged in the boycott had no memory, no historical memory whatsoever of an action that had been taken 55 years previously in Montgomery. At the turn of the century, the black people of Montgomery had entered into a 2-year boycott of the buses when they were initially subjected to segregation. That boycott was successful. So much money was lost that the folks running the buses said, we give. But then later, after the boycott was ended, they brought back segregation, and there was not the wherewithal to start another boycott. That had been completely forgotten in 1955. Seems to me that's one reason why we ought to remember, one reason to remember history. Litigation was necessary. Why was it that the turn of the century boycott lost out? The turn of the century boycott lost out because the boycotters were isolated. They were really not in a position to fight without allies, including the ally of the law. King and company were fighting in more propitious circumstances. Second, retribution. There was tremendous retribution after the boycott. The Ku Klux Klan, after blacks actually started riding the buses, the Ku Klux Klan would go through black neighborhoods, would beat up people. There was just a tremendous amount of retribution in the aftermath of the boycott. There was sniping, violence, all sorts of really terrible things. Segregation continued. Browder versus Gayle gets rid of segregation on the buses, but does that mean segregation everywhere is invalidated in Montgomery? Well, here is an ordinance that was passed on March 19th, 1957 by the city authorities to try to show that even though they had lost in Browder versus Gayle, they were still standing by segregation as much as they could. Here's a city ordinance, March 19th, 1957, declaring it is unlawful for white and colored persons to play together or in company of each other in any game of cards, dice, dominoes, checkers, pool, billiards, softball, basketball, baseball, football, golf, track, in the swimming pools, beaches, lakes, or ponds, or any other games or games of athletic contests, either indoors or outdoors. The city authorities passed that ridiculous ordinance in order to signal that, as far as they were concerned, segregation had suffered a loss in a battle, but the war would go on. Finally, in the aftermath of Browder versus Gayle, there was another response, a response toward privatization. So after Browder versus Gayle, in a number of jurisdictions, what some companies did was they said, okay, fine, what let's do is let's knock off the books statutes that require segregation, and let's privatize the issue. Let's let the bus drivers determine who sits where. That will be a function of private power, and because it's a function of private power, it will be outside of the 14th Amendment, and therefore not subject to Brown versus Board of Education or Browder versus Gayle or the 14th Amendment at all. And indeed, when I come back in a month, the subject of the next lecture is about the attack on so-called private discrimination. Thank you very much. We have a little bit of time. The floor is open to questions, comments, objections. Thank you. Anyone? Yes.
So if you're counsel for the city, and you know a lot of what you know now then, what advice do you give them to either win or lose as little as possible?
Yeah, the advice would have been to have, let's get rid of the excesses. Let's keep segregation, but let's get rid of conduct that even segregationists would be embarrassed by. That's what Jack Crenshaw should have told his employers and the city officials who wanted to maintain segregation.
And you think the NAACP would have stayed out and it just would have been do what Rosa Parks was originally prepared to do?
Maybe. I mean, one of the things that happens during during all of American history In all of American history, one of the paradoxical helpers of reform have been fire-eating white supremacists. God bless them. I told you that I'm from the great state of South Carolina. Those folks who fired on Fort Sumter. I mean, Abraham Lincoln said over and over again, listen, I want to keep the Union. And I'll keep the Union with slavery. I'm willing to keep the Union with slavery. I want the Union. Now, I don't like slavery, but to keep the Union, if I have to have slavery, I'll have slavery. And he was willing to do that. And then the folks in Fort Sumter, the Confederates make war on the Union. And then in order to subdue the Union, Abraham Lincoln passes as a war measure the Emancipation Proclamation and sets slavery on the road to abolition. Well, there was an example of recalcitrance actually leading to much more reform than than Lincoln had in mind. Lincoln was not an abolitionist, though the folks the Confederates made abolition come a lot sooner than it would have come absent their recalcitrance. In the second Reconstruction, same thing. Same thing. I mean, goodness. John F. Kennedy said, he initially proposed a very, very, very modest Civil Rights Act of 1963. Very modest. The NAACP, the CORE, Student Nonviolent Coordinating Committee, all those folks were really angry at Kennedy. I mean, he was very modest. What made him propose legislation that was broader, more rigorous? What made him do that? Bull Connor made him do that. When Bull Connor lets loose the dogs, when he knocks down people with the fire hoses, when he acts in a way which, embarrasses segregationists. Again, it was that recalcitrance that actually helps reform. And that happened over and over and over again. I mean, during most of the Civil Rights Revolution, you could not get a bill passed that would outlaw discrimination in housing. What was it that led to the law that prohibits racial discrimination in private housing? The Open Housing Act of 1968. What else happened in 1968? Martin Luther King Jr. was assassinated in 1968. In fact, the open housing law came after the assassination of Martin Luther King Jr. Again, this was a pattern. And you see it happened in Montgomery. Others? Yes?
So I had a question about the earlier boycott that took place at the turn of the century, and I was wondering why you thought the city didn't similarly step in with that one to put pressure on the bus company the way that it did in 55. And if you thought part of what was going on in 55 was the city felt like this is going to crumble if we don't really step in, and that same sort of concern wasn't there as much at the turn of the century.
Don't know. It's a good question, don't know. Others? Yeah.
As you can imagine, just from looking at me, I remember this time very well. But what I don't remember at all is how the newspapers, and I think there were two, reacted to the boycott. And do you remember, or have you studied, do you know how that worked?
Yeah, they were critical. I mean, as you can well imagine, newspapers are largely dependent on local advertisers, and they were critical. The Montgomery Advertiser, I believe, was the leading paper. They were critical of the boycott, though they were critical of the boycott, though they were helpful insofar as they disseminated just basic information. And so the dissemination of information itself became helpful to the boycott. Though, as I mentioned earlier, the boycotters created their own newsletter because they were suspicious of the papers. And they thought that they might be misled. When one of the great fears of the boycott was that they feared that somebody might, say to the newspapers, the boycott is over, and lead people astray. So again, the boycotters created their own newsletter. They created their own internal government. I mean, frankly, the most glorious days of Montgomery, Alabama were those 382 days of the boycott. Sometimes crises are like that. Others? Yes.
Do you know at the time of the boycott, was the ridership on the buses about 50% white and 50% black, or was it more black than white?
During the boycott?
No, before the boycott. Did the bus company depend about 50% on whites and on blacks for their revenue, or was it a lot more blacks?
A lot more blacks.
Yeah.
Black people were really quite important, a very important a part of the revenue stream of the company. One thing about the boycott, again, in the movies, you take a look at the movies, and the movies, they make it seem as though the boycott was, sort of everybody, all black people were in favor of the boycott. That wasn't true. That wasn't the case. That's hardly ever the case. One of the things that came out in the trial of Martin Luther King Jr. with respect to the criminal prosecution of him for hindering a business without just cause, one of the things that the officials put on the stand, black people who indicated that they had been warned not to ride the buses. Now, frankly, it should not come as any surprise to people that that would be so. Any strike is going to face a collective action problem. And anytime you have massed dissent, anytime you're sort of depending upon solidarity to make your point, there is, of course, going to be the specter of free riders and defectors. And one of the things that was part of the story of Montgomery is, overwhelmingly, there was overwhelming support for the boycott. But along with the overwhelming support of the boycott was something else, which, is part of the story, and, it shouldn't be forgotten. Another part of the story was Black Montgomery. It was quite clear in Black Montgomery that if you were a black person in Montgomery and you rode the buses, your name was mud. If you ride the bus, forget about coming over for dinner. Forget about anybody saying anything when you go to church. Forget about anybody helping you out. Forget about, we've been friends. Well, I tell you what, you ride the bus, you're not my friend. And that, so in any collective action, is there going to be some degree of coercion? Answer, yes. Absolutely. And so, oftentimes when we think about a boycott, people sort of want to, not pay attention to that. But there was that aspect of the boycott. That was part of the picture. What's so remarkable, actually, was not that part of the picture. What was so remarkable is how little internal coercion had to be exacted. The fact of the matter is that Black Montgomery, and here I should add a point, As I said, Black Montgomery. Were there white people in Montgomery who allied themselves with the black people? And the answer is yes. And that shouldn't be forgotten either. Now, were there a lot? No. No, let's be real. No, we're not talking about a whole lot. But were there some? Yes, there were some. There was one in particular. There was the librarian. You talk about the newspaper. There was a librarian who wrote a letter to the editor in which she voiced her support, white woman, librarian, voiced her support for the boycott. And just like Black Montgomery imposed coercion on those who might defect, so did white Montgomery. And when this lady wrote her letter expressing support for the boycott, she was terribly ostracized, and indeed she ended up committing suicide. There was a white pastor in Montgomery who very publicly cast his lot with Martin Luther King Jr. and company. He had his church destroyed. There were white people who were part of the struggle, and indeed throughout the civil rights revolution, there were white people and other people of color, other folks who were not black. In many of the biggest civil rights cases of the 1950s and 1960s, one of the amicus curiae briefs you could always depend upon, Japanese American Citizenship League, always right there with briefs with the NAACP. Again, the anchor for the movement were the black people of Montgomery, but they were not alone. The two judges the federal judges who struck down the segregation ordinances, Reeves and Johnson, terribly ostracized. Reeves is in the days immediately following Browder versus Gayle, Reeves had a son who had very tragically died. His son's grave was desecrated in the aftermath of Browder versus Gayle because people were so outraged at what he had done as a federal judge. Thank you all very much.
Produced by Duke University, online at duke.edu.